Lord, this matrimonial appeal may kindly be listed on Monday next for admission.
Okay.
Like,
May I please, Lordship? I have to mention for listing of a matter in orders column, Lordship. A listing of a matter in orders column, Lordship. IA is pending, Lordship. That's
When?
it. Friday, Lordship. Okay, problem.
May I please, Lordship, I wish to mention one IA on medical ground, my lord. If possible, on tomorrow, my lord.
medical ground?
Lordship.
Okay.
Oh, bless.
Heard, Mr. Yes,
Gupta, Lordship.
Yes, Das Gupta.
learned counsel for the appellant, who submits that the appellant has been convicted under section 302/201/34 IPC by the
Session Judge
Court
Chonai.
Taradio Sonari in sections bracket SC right close number 12 of 2014, arising out of Sonari PS case number 194. With the appeal, call for the PCR, Ms. B. Buyan, additional PP except notice on behalf of the state. Leaves the matter after 4 weeks.
A specific date may be given, Your Lordship.
Date. And then you write in the I,
Lordship,
additional
I
PP
have
granted
suspension of the.
4 weeks to file written objection. The application under section 430 BNSS. This is the matter on the same date.
15, I will be out, Lordship,
When do you want?
prior to December. On 10th, Lordship. 10th
10 December.
December. Obliged, Lordship.
Lordship, the officer in charge is present before this court today, along with a report. Lordship, yes, Lordship, although I could not do the.
Why didn't you appear before?
Sir, at that time, sir, Zubin Garg's expense in Baksa, sir, and high alert is given in the city, sir.
Huh?
Hello situation, sir, Zubin Garg death,
Because of Jubin Garg's death, there's high alert in the city. That's apni Guwahati asile?
What is the sir?
Orders have been
Law
passed,
order situation.
they should.
Maybe before that it was.
Anyway, next time you should obey the orders of the court.
Sure, sir. Apologize, sir.
Regarding the report, my lord,
They've been made.
no, could not be made because Lordship, she's not there, but they have traced out. Page 99.
Yes.
In the result, I sentenced the accused person to suffer RI for 10 years for the offense under 364/34 IPC and to pay a fine of 2,000 each. In default, to suffer RI for another 6 months. I also sentenced the accused person to suffer life imprisonment for the offense under 302/34 and to pay a fine of 5,000 each. In default, to undergo RI for another 1 year. I also sentenced all the accused person to suffer RI for 5 years for the offense under section so and so in default. So the sentence will run consecutively. Oh shit. At one hand it's for life and another hand.
Okay. Whatever. We can change that.
No. No shame. He is behind the bus for last 22 years.
Wait, 2 years.
22 years.
Yes.
As part of cause list, 4 months, 28 days.
He was arrested on 11/12 of 2002 year.
Arrested
On 11/12/2002.
11/12/2000.
Your Honor, may kindly peruse the para number 33 in page number 88 of judgment.
Para 33 years.
Para 33.
Yes.
Come. So now from the evidence discussed above, it is seen that there is no direct evidence against the accused persons. In fact, none of the witnesses examined by the prosecution saw the accused person to commit murder of Rantu Sharma. The prosecution case is solely dependent upon on the circumstantial evidences. So here, my lord, the prosecution has proved some of the circumstances and it appears in support of the case, So first evidence was, circumstantial evidence was, Your Honor, the last scene theory. According to last scene theory, Your Honor, the prosecution stated that Rantu Sharma was seen with the accused Manav Sharma on 10/12/2002 at about 4:30 p.m. while Rantu Sharma was taken away by accused Manav Sharma on his bicycle towards Jangpur. So, Your Honor,
Who are the appellants?
appellant is some village person. He is
What do you mean appellant is village person? Appellant is the
sorry,
accused.
sorry, the Pranab Talukdar and Bhupen Talukdar. Both are in jail, Your Honor.
Acha, what about Manav Sharma? What has happened to him?
So Manav Sharma, as per the court record, Your Honor, FIR, Manav Sharma is a village person who taken away the Rantu Sharma.
So what happened to him? Was he convicted also? Was he made an accused?
Yes,
Then what has
but
happened to him?
there is no detail to me because I am, as a legal aid counsel, I am engaged for the Pranab Talukdar and the,
Okay, yeah, like
Yeah,
for
Bhupen
Pratap Talukdar and the other person.
yeah.
And Manav Sharma, what has happened to him? Was he convicted also?
Accused person, Manav Sharma, he was also in custody, charge sheeted accused.
No, Manav Sharma also was convicted. All convicted. Now what has happened? Did he file an appeal? Manav Sharma?
Side bonege, criminal appeal. Manav Sharma, district to কি হয়? District to কি হয়? হয়। MA, NAB, SAR, MA,
District is Nalbari,
Nalbari district.
Nalbari district. Thousand.
Appeal 2023.
Against
He was convicted in 2003. 2003.
2003.
23? Cannot be.
Nalbari niki.
2003. 2003.
Whose
But
name
this
is that?
appeal is of 2023. Man, date kya is?
They have filed
Acha,
after 20 years or 19 years.
Can you call for the record?
Jail notice.
No problem, no problem. Allowed, can you just find out? You've got no idea what happened to Manav Sharma
I don't have. I don't.
because
I'm engaged.
we have got to be slightly careful also.
I know.
है ना? If there is a clash.
Judgment is of 2003. They have come in 2023 after 20 years.
After 19 years, yeah.
District to Milise. Oh.
Huh? Okay, not 2000. 2003. This appeal is- Please.
SCRM, yeah.
No problem. Okay, so you can tell us. So, so basically, the child was being taken away.
by the Manav Sharma.
Manap Sharma.
And none had seen that Pranab Talukdar and Bhupen Talukdar had murdered the child,
Yeah.
committed the murder.
So they have been convicted on the basis of the evidence given by
On
Manap.
circumstances,
Huh?
on circumstantial evidences.
Well, what is the circumstantial evidence?
The first was, it was in para 33, Your Honor.
There is confessional statement, there is leading to discovery.
This whose confession statement?
Confessional statement of Pranab Sharma, Pranab Talukdar, Bhupen Talukdar,
Okay, okay.
and there is leading to discovery.
Asha, it led to
There is extrajudicial confession.
extrajudicial.
Yes.
But Your Honor, there is something else.
Let us see. Para 30.
Your Honor, may peruse the page number 59. Your Honor.
Just a minute.
Page number 59.
Just a minute. Extrajudicial confession. Both. Okay, so basically the facts are like this. Ratu Sharma was seen with Manab Sharma. Okay, then demand letter was recovered from Manab Sharma. Correct?
But demand letter, no authority is there, no signature, nothing is there.
So anyway, you are not with Manab.
And under section 330, Manav Sharma is denying that it was not found from his.
Anyway, you are not Manab Sharma's counsel. How does this work? Next is that extrajudicial confession made by Manab Sharma. But Manab Sharma's extrajudicial confession cannot incriminate another, it can only incriminate him. Then Manab Sharma led the police to the appellant, to you. And you led the police to where the body was. Is that correct? And there was recovery of weapons from Pranab Talukdar. And did you make some confession under 164 CR?
No, Your Honor, in 313 examination, Pranab Talukdar stated
Oh,
it is
there's a
not so.
one in
He
it.
made confession out of torture of the police. Page number 59.
Let us see. Confession. Pranab Talukdar is at page 118. What about the other? Did he make any confession?
And the other is, Your Honor, page number 64. It is true that I said, but I said so out of fear for the police.
No, that is not a confession, madam. Please. That is a 313 statement. 313 is not a confession.
Yes.
At best, it can only be an explanation. It is not a confession. Please understand that. Okay. 64 is a statement. That can be a confession also. Now, 164 has been made only by this Pranab Talukdar. The other appellant,
Other applicant also done, Bhupen.
he has given a 164.
Yes, ma'am.
Where?
Page 137. 130 onward.
130. That is Bhupen Talukdar. Okay, both of them are here. Now, where is the confession of the other person?
Oh my God, Bhupen.
Not Bhupen, the other one.
Pranab.
Pranab Talukdar. Confidence at page one.
Pranab Talukdar is here. Where is Bhupen's?
Page is at page 130 onwards. Page 137 is the content.
130 onwards.
137 is the content. And from 130 onwards, it starts, ma'am.
Okay. 130 is by
Bhupen.
name is not here.
Yes, sir.
Where?
On the right side, page 1.
Okay, 131. But where is Pranab Talukdar?
Here it is page number, Your Honor. 120.
125.
Start from page 118, madam.
Okay.
In page
For 3,000 rupees, they kill the boy.
1003.
Oh, 3,000.
Okay. Demand letter which was seized of 1 lakh rupees.
So,
Demand was not 3,000.
no, but at page 125, it says 3,000.
Yeah, but which was seized by the one money demand.
No, that is all right.
Demand.
But this is,
From the cut from
this is
mouth,
a,
yes,
this is a 164.
yes.
Can we change
No,
the
no,
words?
Lordship, it came out from the mouth of the accused person.
Yes, what have you got to say, madam? Let us hear you now. We are ready.
My only submission is that, Your Honor, none had seen the commit of murder.
No one expects to see it.
So
It's all
the
done in
Manav Sharma is seen by the all the examined witnesses. There is no evidence that Pranab Talukdar and the accused has commit the murder.
So when was the 164 statement recorded? Which date? Twenty-one 12/2002.
2002, Your Honor.
Okay, so no one saw the murder.
Yes.
Yes.
And Your Honor, there is absence of the any forensic expert report or nothing is there. No handwriting expert that regarding the circumstances that are demand letter, circumstances number 2. Regarding the letter of demand letter, there is no writing expert report is also there. Only on the presumption they were. Except the confessional, that also they are not saying that they are out of fair taste.
So they've been convicted because of what? Because because of the recovery of the body. On
Sir,
the-
read a confessional statement, your lordship, let us see minus. Para 33. Now,
Still statement
yes,
in the judgment,
yes, para 32 of the judgment,
page.
page 88. Now, from the evidence discussed above, it is seen that there is no direct evidence against the accused person. In fact, none of the witnesses examined by the prosecution saw the accused person to commit murder of Rontu Sharma. The prosecution case is solely dependent on the circumstantial evidence. The prosecution has proved some of the circumstances in support of his case. Let me now examine whether the prosecution has proved the charge with the help of circumstantial evidence, and whether the circumstances proved as sufficient to convict the accused under section 30234 IPC. The first of the circumstances was the last seen theory. It has been proved by the prosecution that Rontu Sharma was seen with the accused Manav Sharma on 10/12/2002 at about 4:30 p.m. While Rontu Sharma was taken away by accused Manav Sharma on his bicycle towards Jangpur, PW1 Chintu Malla, Bojar Borua and PW2 Chandan Kolita has proved the fact that the defense could not shake the credibility of these two witnesses in their cross-examination. The other witnesses also have deposed while they were in search of Rontu Sharma. PW1 and 2 reported to them that they had seen the deceased for the last time with the accused Manav Sharma. The second circumstances proved by the prosecution is that recovery of a demand letter from the possession of accused Manav Sharma, which clearly indicate that he kidnapped Rontu Sharma with intention to demand ransom from his father. Defense did not question the recovery of the demand letter from the possession of the accused Manav Sharma, neither they disputed the authority of the demand letter. The demand letter does not bear the name of the addressee and the author, but as the defense did not challenge the authorship of the letter, it can be accepted that the letter was written by accused Manav Sharma, which reveals that he kidnapped the deceased for the purpose of demanding ransom for his father. The third circumstance is the extrajudicial confession made by Manav Sharma in presence of village people before arrival of the IO. When he confessed before the village people, he kidnapped Rontu Sharma and kept him in custody of some boys in Sonpur. The fourth circumstance proved by the prosecution is that accused Manav Sharma led the police party first to Sonpur and Laudal and secondly to Jangpur to the house of accused Bhupen and Pranab, and both the accused Manav Sharma and Pranab Talukdar led the police party to Dole Pathar and showed the grave where they buried the dead body of Rontu Sharma. Another circumstance proof against the accused person is the recovery of the weapon of the offense at the instances of the accused Pranab Talukdar. Another circumstance proved by the prosecution is that all the accused persons simply denied the circumstances which were put to them under 320 CRPC. For the explanation, simply denial of all the circumstances by the accused person also can be taken as a missing link in a chain of circumstances. The blunt denial of all the incriminating circumstances by the accused can prove the missing link in the chain of circumstances. In my view, the prosecution has proved the following against the so-and-so. Now, from the circumstance proved by the prosecution supported by the other evidence on record, it can be held without hesitation that all the accused persons committed the murder of Rontu Sharma in furtherance of common intention. From the confessional statement of accused Bhupen Talukdar and Pranab Talukdar, it can be clearly seen that it was accused Manav Sharma who kidnapped the boy first and handed over to accused Bhupen and Pranab near the abandoned army camp with a promise to give them rupees 30,000 each if they can kill Rontu Sharma. It is seen that the confession of Pranab Talukdar and Bhupen Talukdar was recorded by PW15 after giving them sufficient time for reflection and after observing all the formalities as required by section 164 CRPC. Both the accused persons were produced from judicial custody at the time of recording their confessions, and during the time of recording their confession, there was no fear or influence of police, and they were cautioned time and again that they are not bound to make the confession, and if they do so, the confession could be used against them in trial, and in that case, they may be sentenced to jail from several years. Both the accused persons were given more than sufficient time for reflection, and after fully being satisfied regarding the voluntary nature of the truthfulness of the confession, recorded a confession, though the accused Bhupen Talukdar and Pranab Talukdar in their statement under 313 stated they confessed because of the fear of police or taught by the torture by the police, but such an explanation cannot be accepted as this would be afterthought. The accused person did not clearly retract their confession, and therefore the confession statement can be accepted as true and voluntary nature for the purpose of conviction. Then, Lordship, there's a line. But the confessional statement of the Bhupen and Pranab being that's the same line, page 91. But the confessional statement of Bhupen Talukdar and Pranab Talukdar being the confession of the accomplice cannot be used for the purpose of conviction of co-accused Manav Sharma without sufficient corroboration. In the case in hand, it is seen that the confession statement in both Pranab and Bhupen Talukdar are inculpatory in nature, and the confessions have got sufficient corroboration in the evidence of the other witnesses. This being the position, I am of the view that there cannot be any bar in convicting the accused person on the basis of confession statement plus other circumstances evidence proved by the prosecution. So probably, Lordship, the prosecution could prove the case, my lord, beyond all reasonable doubt.
Let us see the evidence which says that the body was recovered at the instance of this appellant.
Hold up.
My lordship, page number 10, PW1. I know the father of the victim, Sri Horen Sharma of Sankusi. I also knew the deceased. I also know the accused person who are present in the dock today. I also know the informant Satish Sharma on 10/12/2002 at about 4:30 p.m. while I was sitting in front of my house in Bamboo Sun. At that time, I saw one of Sharma to take away Rontu and Santanu, Elias Santanu on his bicycle from the southern side towards the northern side. In the evening, when some people came in search of Rontu Sharma, I came to know that Rontu.
Madam, we'll just rise for 2 minutes. We'll come back.
Oh, okay.
Because the white order dated, my lord, Jasmine and order dated 21/12/2002.
Ah.
This on 8/1/2010.
10.
This honorable court in criminal appeal 100G of 2003, preferred by Manav Sharma and two others, maintained conviction of these two appellants.
Oh,
Lordship, may kindly have a look. It's in the order. It's lapses on our part. We could not, Lordship.
That's why I asked for the
My lord.
statement.
It was in the record itself. Honorable Ranjan Gogoi and H. Roy ji.
Again, concession judge in sections case number 2 of 2003.
Same, no? Okay, no? 2 of 2003.
2 of 2000. Same.
Two of 2003.
Yes, yes.
Yes.
18/6/2000.
So this appeal is not maintainable. Maharashtra probably acquitted, my lord, from the charges.
Yeah, so a bit of that. No one brought out this. That's why we call for the report.
No, it had not come. I verified in the record itself. It
In
has not come from the
LCR.
registry.
Oh.
It was in the LCR itself.
Well, okay.
They could
Anyway,
not trace
so,
out.
anyway, so. Her,
Actually, some remuneration, sir, her fees be paid.
how much will she get
As per,
No,
for the rate?
yes.
Not required, huh?
not
No, no,
required.
number of times she has
No.
done, my lord. We should appreciate
We'll
it.
give you. You can. Heard Miss
I was son. I was son.
R. Goswami, learned amicus. Amicus or what are you?
Legal counsel?
Legally
Learned
counsel.
legally
Legally counsel.
appearing for the FL. Also heard Miss B. Boyan, learned additional PP. This is an appeal filed by the FNN's Pranab Talukdar and
Bhupen Talukdar.
Bhupen Talukdar against the impugned judgment dated 18/6/2003 passed by the Sessions Judge Nalbari in Sessions case number 2 of 2020, 2 of
2000.
2003, by which the above two appellant and one Madhav,
Manav.
Manav Sharma.
one Manav Sharma had been convicted under section 364/34 IPC, 302/34 IPC, and 201/34 IPC. After hearing the at length, we have noticed that the present two appellants had already filed an appeal earlier in this court against the said impugned judgment, which was registered as
Criminal appeal 100J.
criminal appeal number 100/J of
Oblique.
2003. Inverted commas, Manav Sharma and two others versus the state of Assam. Next para. Next para. Criminal appeal number 100/J of 2003 was disposed of by judgment and order dated 8/1/2010 by this court by acquitting Manav Sharma and at the same time upholding conviction and sentence of the present two appellants, Bhupen Talukdar and Pranab Talukdar. And the sections 364/302/2001, 201, read with section 34 IPC. Full stop. Next paragraph. In view of the earlier judgment and order dated 8/1/2010, passed in criminal appeal number 100J of 2003, the present appeal has become infracted. The appeal is accordingly closed as not being maintained. Full stop. Next paragraph. The above being said, in view of the assistance provided by the learned legal aid counsel, her fee should be paid by the Assam State Legal Services Authority as per their norms. That's what send back the TCR.
Right.
Well, good. We disposed of one very.
All right.
So luckily, we went out for 2 minutes.
Yes, my lord.
Otherwise, we would have continued
My lord.
hearing her.
It just clicked my mind. Let us verify once.
Right.
So the P02, conviction RI for life, along with punishment for 5,000, fine of 5,000. But there is no eyewitness. 6 witnesses are there, all are circumstantial. And one witness would have been the eyewitness, the wife of the accused himself. Allegation is that there was a quarrel between the accused and his wife. So the informant's husband came to intervene and to pacify the situation. And that in that moment, that accused gave him a blow, and single blow, and he died. And all the witnesses are hearsay witnesses. Nobody has seen. And one GD entry is there immediately after the incident. GD entry that was exhibited by the PW6, the investigating officer. GD entry also, it was said that someone has informed that one labor killed another labor. So nobody has mentioned anybody's name. And there was 2 adjacent tea estates. The accused, one tea estate belonged to one witnesses that his statement is reported, the Rajan Bora, victim. Victim belongs to his labor. Victim is a labor of Rajan Bora's tea estate. And another tea estate owned by Somnath Bora. The accused is a labor of that tea estate. Their quarters were adjacent. So, the husband of the informant went to the residence of the accused, and then incident took place. So nobody says whether at that time that accused was there present in that quarter. So on that basis, that
Where was he killed? Where was he killed? He was killed in the residence of that other person.
he was
or
found
in your
dead.
house.
Yes, he was
Found
found
in
dead.
your house.
Yes.
So he did not fly after his death to your
So
house.
whether, my lord, he was there present in the quarter or not at the time of the incident, that is except, my lord, the hearsay evidence.
What is your version? Were you there in your house?
No, I was, my lord, labor lordship knows that after the day-long work, they went to for some, my lord, lordship knows that.
I don't know. I don't know.
Because those are not in evidence, even then. And but the conviction was only on the basis that there is no explanation that the dead body was found in his house.
106.
But he must be there, my lord. If he is not there,
So what is your alibi? Do you have an alibi?
But nobody has seen Malad because nobody's statement is there that at that time he was in his quarters.
Supposing a dead body is in this courtroom,
Malad.
there is no lawyer, just me alone. Then what does 106 require? That I should explain why that thing is here within the confines of this courtroom.
And Malad,
You
He's
can.
the wife of the accused was also there.
Well, that is
But she has not been interrogated nor she was examined.
probably cooking in the kitchen.
And someone said that the dead body was found in the kitchen, and somebody says it is found in the veranda. And murder weapon was not seized.
But what about you? What do you say? Were you there, or you had gone to some your neighbor's house, or
Regarding Malad, he did not adduce any evidence. And in his
No, it is 313.
313 he merely denied.
Right.
Denied.
So you have got no alibi.
No, there is no plea of alibi. Malad.
If there's no plea of alibi, then you were there. Then you should have some kind of explanation.
That is true, but Malad, one more thing is that the murder weapon was not seized. Whether it was caused by the PW1, the informant said it was by Dow, Malad. Or whether it is Dow or some other, and the murder weapon was never seized. And whether had the murder weapon seized, Malad, did the thumb impression?
Injury report say.
Malad, one single 4 into
Is it a cut blow? Is it a cut?
cut blow. 4 into 2 into 0.5 cm.
So basically, maybe come to 304.
Because of the
At
quarrel.
base, Malad, at base. But
Because of the quarrel,
Because of the quarrel, and you intervened in the quarrel.
yes.
there is no evidence that there is any enmity.
Previous enmity. there
No,
was.
no evidence.
You see, because the thing is that no doubt there is no witness and all. But you see, no one murders a person usually
Yes.
in front of everyone. He's not going to call everyone through a loudspeaker. Come, everyone, come and see. I'm going to kill. So no one does that.
No, that is the
So you
that-
see, it's usually done when no one is around. So the thing out here is maybe that there was no intention to kill, nothing, but you intervened while he was in
Yeah,
a
my lord.
aggravated state of mind.
Here in this,
You have to give an explanation. Where were you?
yes, but my lord, here in this case,
Were you in the toilet? Were you in the kitchen? Were you upstairs? Where were you? Under the ground? Where were you?
yes, but my lord, here in this case, IO had the opportunity to examine the wife, my lord.
Forget the wife. What about you? You're the head of the family. You have got to explain what happened inside your house. A wife has to explain, no doubt, but
the
you.
prosecution has to prove the case beyond reasonable doubt, my lord.
Correct, but 106 is an exception. One 106 is different.
And Ladat court below also admitted, while pronouncing the judgment, that there are some my lord, negligences on the part of the IO. So far the and my lord, and 2 persons, my lord, and 1 person, my lord, I'm coming to one statement, my lord, PW1. There are other 2 neighbors. Those persons were not examined. In cross-examination stated, residents of us and that of accused were closely situated. Near to the residence of the accused, there were houses of other peoples, namely Onil Gwala and Kunti Gwala. These persons were not examined.
No, anyway, look, at the end of the day, everything happened within your house.
Yes, that is true.
So even if there were neighbors might not know what goes on within the confines of your 4 walls. So you have to explain as to what has happened. You're not giving any explanation. You're only talking about the weakness of others. What does 106 say? Let us see evidence that.
Evidence. burden of proving facts, especially within knowledge. ಇದು ಮಂತು ಲಗಲು ಮಾಡ್ಸಿಲ್ಲ.
Yes. Look at 105, 106. One zero five is not applicable here. 105 is different, but 106. When any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. Now, when it has happened in your house,
Yes.
and it is not your case that you are somewhere else, then you should be having some knowledge. Your house is what? How many? You got 30 rooms or something?
So there is a quarter, my lord.
How many rooms in your quarter?
There might be 2 or 3 rooms, my lord.
2 or 3 rooms. Then you don't know what's going on in 2 or 3 rooms. He's a laborer.
Well, the labor, my lord, was in Bagan. Well, after day long work, they used to normally went to for some have some drinks, some so this.
So drinks is where? In the house or outside?
That is I cannot say because that is not in the environment. That is my lord.
Yeah,
That is only my perception.
Correct. Yeah. Perception is correct, but then you have not taken that alibi that
Yes,
you had
sir.
gone
Yes.
not in the house.
My lord, here, my lord, I have found several, my lord, infirmities in the investigation.
Let us see.
Yes.
Now we have heard. Let us see the evidence. Let us see the FIR.
FIR. Finally come to page 4 of the paper book. my lord.
Yes.
I, the informant, have the honor to state that at about 10 p.m. on 22/6/2019, accused Dhania Sobar, who serves in Somnath Tea Estate situated near our tea estate, killed my husband by hacking him with a dao following an altercation on Trifle Manor. That which serves as laborers in the small tea estate of Rajan Bora. My husband had to embrace death as he went to the house of accused 10 p.m. to subside quarrel between the couple. I therefore honestly request you. So this is the FIR.
Let us go to the evidence.
Yes, her evidence at page 8 my lord. And subsequent to the death of her husband, she got married with another person.
So, how does that?
So, my lord, I am just pointing out, my lord.
Death of her, she married, so
Well,
how
but-
does? So what?
I am just, my lord, submitting, my lord. Because, my lord, that part is not in the evidence, my lord, otherwise. Immediately
What
she
is
got
the relevance of it? What is the relevance? No relevance.
Well, I am just pointing because well, there may be any other third party.
You mean to say that she might have killed her
I am
husband.
not specifically. I am not.
Why should she kill her husband
I am
in
not speaking.
her neighbor's house? Not in her own house.
Yes, my lord. I am only, my lord, because I am not submitting specifically because my lord, there is no such evidence. That is why these are perception only. Page 8, my lord.
Unless you have cross-examined
Yes,
the witnesses on that aspect, how can you presume something?
yes. I am the informant of this case and I lodge Azahar against the present accused. The incident took place in the year 2019. At that time, myself and my earlier deceased husband Bijoy Tati, who were working in the private tea garden of Rajan Bora, whereas accused worked in the private garden of Somnath, and both the gardens were closely situated. Both the gardens are situated at Zaporiguri. We used to live in the house allotted to us by our garden owner in the garden where we worked, and accused lived in the house allotted to him by his owner in the garden where he works. On the date of occurrence at 10 p.m., I went to watch TV in the house of one called Purnima, and my husband went to the house of accused Dhania to intervene the dispute cropped up between the accused Dhania with his wife. And on intervention by my husband, the accused cut on the neck of my husband as my husband died at the spot. There was hue and cry about killing of men by Dhania. Hearing hue and cry, I returned to home and did not find my husband, and as such, I went to the place of occurrence where I found that my husband was lying in almost dead condition in the kitchen of the accused. And while I potholed my husband, he succumbed to injuries. I saw cut injuries on the neck of my husband. After the incident, many people, including owner of our garden and the owner of garden of the accused, including other peoples, namely Santori, wife of Rajan, Huda of Pani Tank, and other arrives at the place of occurrence. At around 12 midnight, police arrived at the place of occurrence, took the dead body of my husband. On the next day morning, I went to Jinja police station and lodged Ejahat. Now, cross residents of us and that of the accused were closely situated. Near to the residence of the accused, there were houses of other peoples, namely Onil Gwala and Kunti Gwala. These persons were not examined. The incident took place at night. I was watching TV while the incident took place. After hearing Hulla, only I came out from the place where I was watching TV. Nobody told me that accused Dhania murdered my earlier husband, but I found the dead body in the kitchen of Dhania, and as such, I inferred that accused Dhania murdered my earlier deceased husband. It is not a fact that I have deposed falsely that accused Dhania murdered my deceased earlier husband. So she presumed, my lord. Now, PW2.
Yeah.
I know the informant Kamala Tati. I know the Dhania Sabur present in the dock. The incident took place around 10 p.m. One night about 3 years back in a quarter of Somnath Tea Estate. I was not in my own house. I was watching television in Somnath's house. After hearing a noise, I come to the quarter of Somnath Tea Estate. I found that Suklu, the husband of Kamala Tati, was lying dead in a quarter of Somnath Tea Estate. The accused Dhania Sabur was present inside the quarter.
So the accused Daniel Sabor was present inside the quarter.
He said. But other witnesses, Malad, said they have not
One is
said.
enough.
Yes.
Have you denied this? Have you cross-examined this?
Malad,
witness saying that
cross-examined, but that part not brought.
You are there inside.
Yes. The neck of Suklu was found cut. The villagers told the accused Dhania Sabur hacked Suklu. I did not see who hacked Suklu. The villagers informed the police. The police arrived there and took away the dead body. Thereafter, the wife of the deceased lodged this case against the accused. I went to watch television alone. I heard hue and cry from 1 p.m. away. At first, about 10-15 villagers came here. About 10 persons were already present at the place of occurrence before I reached there. The accused Dhania Sabor was suspected as the deceased died in his house. The police did not question me. The police has not examined him. I have stated that Dhania Sabor had killed him, as I heard so from other villagers. This Somnath Thapama, this PW3, he is the owner of the tea estate where accused works. I know the informant Kamala Tati. I know the accused Dhania Sabor present in the dock. I knew deceased Bijoy Tati. Bijoy Tati was the husband of Kamala Tati. The incident took place at about 10 p.m. On 22/6/2019, the incident took place in a laborer's quarter of my tea estate situated at Japoriguri. Dhania Sabor lived in that quarter with his wife, with his family. At the time of incident, one Sutka, a laborer of tea estate, informed me that Dhania Sabor had hacked Bijoy Tati. This Sutka was also not examined. The husband of Kamala Tati, I along with some other persons, came to the place of occurrence, that is the quarter of Dhania Sabor. Sitaram Setri, Bhaskar Setri came to the place of occurrence with me. Thereafter, we saw that Bijoy Tati was lying at the veranda of the quarter of Dhania Sabor. So he said, dead body was found in the veranda. We saw that Bijoy Tati was wet with blood. Bijoy Tati was in a moribund condition. There was cut injury on the neck of Bijoy Tati. The tea estate of Rajan Bora is also situated near my tea estate. Bijoy Tati was residing with his family in the quarter of the said tea estate. The quarter of Dhania Sabur and the Bijoy Tati was situated adjacently. I informed Rajan Bora. Rajan Bora also came to the place of occurrence. We informed Jinjia police station of the incident over phone. The police came and took away the dead body. The laborers present in the place of occurrence told that there was a quarrel between Dhania and his wife. Hearing the quarrel, Bijoy Tati came to the Dhania Sabor's quarter. I heard that Dhania Sabor had Bijoy Tati following a quarrel between them. The Dhania Sabor said so in the police station. My tea estate is 1 kilometer away from the residence. I was sleeping. I do not know whether Dhania Sabor was in his quarter at the time of occurrence. I reached the place of occurrence within 5 minutes after knowing about the incident. There were 5-6 persons at the place of occurrence when I arrived there. I do not remember what clothes Bijoy Tati was wearing while he was lying there. It is not a fact that I did not go to the place of occurrence. The police questioned me at the place of occurrence. It is not a fact that I did not state in my statement made before the police that a laborer, Sutka by name, informed me of the incident. It is not a fact that I did not say in my statement before the police that Sitaram Setri, Bhaskar Setri went with me. I did not say to the police that I learned from Moina Sobor that Dhania Sobor had killed Bijoy Tati. I did not say to the police that I rang up Rajan Bora. I did not see Dhania Sobor at the place of occurrence when I reached there. I did not see who killed Bijoy Tati. So well, he said Dhania Sabor was not at the place of occurrence when he reached. When I reached there, I did not see who killed Bijoy Tati. Since Dhania Sabor was not available in his quarter, I was suspect that he killed Bijoy Tati. Rajan Bora's statement is also similar. I am reading the cross part. I know the informant Kamla Tati. I know the accused present in the dock, but I do not remember his name. The incident took place at about 10 p.m. So and so. Somnath Thapa informed me over phone that Bijoy Tati of my tea estate had the accused. I immediately went to the place of occurrence. After arriving there, I saw that Bijoy Tati was lying in the quarter of Somnath tea estate in which accused and his wife had been residing. When I saw Bijoy Tati, he was lying in grievously injured condition in a moribund state. Jinjia police station was informed and police arrived there. The wife of the accused, Dhania Sabor, told that Dhania Sabor cut Bijoy Tati
Who is
when
the wife of Dhanesh Sabor?
she was not examined. She was not examined. He came to subside the quarrel that cropped up between Dhania Sabor and his wife. The police took the Bijoy Tati. It was not. It was about 11 p.m. when I reached the place of occurrence. I went to the place of occurrence alone. 20-25 persons had already gathered at the place of occurrence when I arrived. Somnath informed the police. I did not say to the police that Somnath informed me of the incident. I did not tell the police that the wife of Dhania Sabor told me that quarrel had taken place between her and Dhania Sabor, and that Dhania Sabor cut Bijoy Tati when he had gone there to subside the quarrel. I do not know the actual reason for the incident. So medical PW is 5 mil. Medical, it is found that one incise wound of size 4 into 2 into 0.5 inches over the left area of larynx, extended up to left posterior inferior auricular area or cervical vessel. And IOML, he stated that this PW 3 and 4 did not stated before him that wife was not, and she admitted that wife of the accused was not examined. And in his cross-examination, he stated that it is not a fact that Raju Sautal and Onil Sautal did not state that Dhania Sabur killed the deceased. I did not seize the weapon in connection with the incident. So, my lord, only because of the fact that body was found in his courtyard, and there is no explanation in that regard. Conviction was given.
Who is this Raju Sotal and this is Raju and
Raju Sautal and Onil Sautal. One Onil Sautal was examined. Onil Sautal was examined as PW2. Raju Sautal was not examined. So there is no direct evidence to show that the accused appellant was the murderer. Only presumption, as because dead body was found in his quarter. And single blow, my lord. Even
vital part?
vital part, my lord, vital part is there, but only single attempt, my lord. That may not be intentional, because vital part unwilling, unintentional, maybe, my lord, because he may not have, because there is no enmity. He only went there to pacify the situation. So there may not be any intention to kill him. And prosecution also failed to establish that there was any intention, there is any motive in that regard.
Finish?
Lordship here, PW1 and PW2. PW2 have specifically stated Dhania was present inside the house. So, Your Lordship, and PW1, the wife of the victim, he said 10 p.m. She went to watch TV. Wife went to accuse Dhania to intervene the disputed, as regards dispute has taken place, my lord. So, in the event of the matter, Your Lordship, when the dead body was found in the kitchen of the deceased person, accused person, there should have been an explanation under 106, my lord, which he could not discharge. And presence of the accused person was well established, and he did not take any plea that he was not present at the place of occurrence at a relevant point of time. Regarding the non-examination of material witness, and regarding the lordship, other aspect, that the wife of the victim is a related. Lordship, I may be allowed to place two judgments. Lordship, since the accused could not discharge the burden, although it was on the vital part of the body and there was a single blow, that aspect your lordship will may consider, my lord. But the accused person was the perpetrator, my lord. Because he did not explain anything. That somebody else was there, somebody interfered, somebody was like, lordship was present while committing the crime, my lord. Nothing, my lord. When he chose to remain silent when the occurrence had taken place inside his house. That too at 10 p.m., your lordship. These are the circumstances which goes against him, my lord. And a motive is, your lordship, in circumstantial evidence, motive is an important factor. But PW1 has stated, in order to intervene into the dispute, he went there. So in the event of the matter, there's a possibility, your lordship, that the occurrence had taken place, that the accused person committed the crime, my lord. Other aspect, I don't find any other material, your lordship.
What about this Sutta? Why wasn't he made a witness in PWP's evidence?
No, well, Supta was also not that much.
Not made, that's why.
Lordship,
Examined.
so may I please one judgment on non-examination of material witness, Lordship? Raja alias Rajinder, Dibone Kitapkon versus State of Haryana. Era 13 and 14. Para 13. In an instant case, the circumstances that have been established by the prosecutions are that deceased had accompanied the appellant accused being called by him from his house in the early part of the evening on date of occurrence. The mother of the deceased, Kalawati PW11, was deposed in that regard. Thereafter, from the material brought on record, it is clearly revealed that the appellant was seen at the tea stall with the deceased. The said fact has been deposed by Mahendra PW10. Thus, from the aforesaid evidence, two facts are established, namely, the accused and the deceased had left the house of the deceased and were seen taking tea together at a tea stall. It is submitted by the learned counsel for the appellant that the last seen theory as advanced by the prosecution is not acceptable in as much as the owner of the tea stall has not been examined. When the testimony of the aforesaid two witnesses deserve acceptance and receive corroboration from the other evidence on the record, no adverse inference should be drawn because of non-examination of the tea stall owner, who, as has been submitted by the learned counsel for the appellant, is a material witness. It is well settled in law that non-examination of the testimony available on record, if the same is natural, trustworthy, and convincing, that apart he was not such a witness who alone was the competent witness to depose about a fact that his non-examination would really destroy the person of the prosecution. Another reason for accepting of the last seen theory is that the brother of the deceased, Subhas PW8, has testified that he inquired from the accused as regards the whereabouts of the deceased. For the deceased had accompanied the accused, and at all junctures the accused had replied that the tea stall, a sick boy came and the deceased went with him. As per the prosecution case, the deceased and the accused are co-villagers. In his statement under Section 312 CRPC, the appellant accused totally denied to have accompanied the deceased. The learned trial judge and the High Court have placed reliance on the evidence of the mother Kalawati PW11, the brother Subhas PW8, and the Mahendra PW10. The cumulative reading of the opposite appreciation of the said evidence proves beyond reasonable doubt the deceased was last seen with the deceased, with the accused, my lord. Lordship, PW13 would be relevant. If the other witnesses prove the case, then non-examination may not be fatal, man.
But who has proved the case here?
Has not proved much, but while the offense has been committed in like four corners of a house, and when PW1, let us discard PW1 being the wife. Other witness PW2, Anil Sautal, dead body found in quarter neighbor of Dhania. Dhania was present inside the quarter. So why to disbelieve him? He could not be his witness. His evidence could not be shaken, my lord. So in that event of the matter, your lordship, whether to discard their evidence, your lordship. And 106 burden has not been this one by the accused person, discharged by the accused person. But regarding this single blow, whether your lordship will convert it to 304 part 1, because it was on the vital part of the body, my lord, that your lordship will decide.
There is no recovery of weapons.
There is no recovery of weapon. No, ma'am.
Why wasn't the wife made a witness?
My lord,
Why?
a wife of the accused. She was none of her children were also present.
Huh?
Children were also there.
Children were there.
Huh?
Children was not there.
No.
Not in there.
Oh, not it.
Not-
Warrants are like
No.
EW 3 to 2 person.
No, no.
But what would be the reason for killing?
No reason, my lord, because out of grave and sudden provocation.
We don't know. No one.
There was quarrel, my lord.
Quarrel between wife and husband,
Yes.
not between him.
Mhm. Single room only not. Husband and single room. Husband is single. Why am I sticking things? Interview posting. Oh. Lordship, may I point out one thing also, although it goes against us? Lordship, the postmortem report, although it's suggestive, my lord, time seized date is shown as 18 hours. And examination was done at 11 a.m. on 23/6, and date of occurrence is 22/6, 10 p.m. So it cannot be 18, although it is suggestive, lordship in that may vary. কি করছে না না বলিয়ে জন্য চাষি তো সিঙ্গল ভাবে কর
Custody since when?
My lord, immediately after the incident.
2000?
He was arrested on 26/6/2019. After
Been
4,
in jail.
yes.
Ms. Sharma, you're there for the next case.
Sharma, Vijita. No, she probably in her case, a report would be necessary regarding remission. Remission, my lord.
And my case, item 10, Lordship.
Yes.
In that case, Lordship, he has completed the required years for remission of his sentence. It's a life convict. And so, Lordship, the IG Prison has sent his matter for the review board for consideration. And on the last date, Lordship fixed today. But one thing may be probably required that what is the present status before the review board? That report perhaps is necessary before hearing Lordship. So there may be a direction in that case,
The
Lordship.
last occasion submitted communication, no? Regarding the status of
Okay,
his,
we'll take the
yes.
And
My lord.
you see, the laborers and all, none of them have been made witness. Very difficult. One and three.
But presence is proved, my lord, that the accused person is present at his place. That is proved. And that may not, lordship,
That is the only thing. That's
yes,
the
my
only-
lord.
But there's no weapon, nothing.
Weapon, my lord, lordship is aware of maximum cases, lordship, defect in the investigation.
How do we apply 304? Because.
Because it's 30,
The
part-
exceptions to 300 will have to be proved.
yes.
That-
Exception 4, whether it would attract money.
Fight, there has to be a fight.
Without passion upon a sudden quarrel.
But it has to lead to a fight.
Mm.
There's no fight. That quarrel has to culminate in a fight.
Yes.
Okay, we'll take it up at 2.
Well, one more judgment is coming on, reported on SCC online 2000, it was delivered on 22nd of September 2025 by Honorable Justice Padiwala and Manoj Mishra. Regarding 106,
Okay.
106, it is stated that, unless the prosecution, if prosecution failed to establish the case beyond reasonable doubt, they cannot take result of the 106 only to prove the case. So, my lord, I could not go through the entire judgment because judgment is very long, 90 pages judgment, my lord.
If there is beyond reasonable doubt, then 106 is not required anymore.
Yes, my lord, that is why. That is why, my lord, I am saying that only.
No, but if we have to accept your logic, your submission, then there is no requirement of 106 if prosecution has to prove the case beyond all reasonable doubt. 106 is not required.
Yes, so in this case, my lord, they have failed to prove the case on beyond reasonable doubt.
Why?
By adducing evidence. No witnesses, my lord, they supported the case, my lord, that the accused appellant, my lord, murdered the victim. So in that case, my lord, only taking result of 106, my lord, regarding the judgment, one particular paragraph, my lord, paragraph 79 onwards. I'm reading only one part, the one portion, my lord. It's a state of Madhya Pradesh versus Balbir Singh. But, Section 106 of the Evidence Act would apply to cases where the prosecution could be said to have succeeded in proving facts from which a reasonable inferences can be drawn regarding guilt of the accused.
That reasonable, reasonable what?
Inference can-
A reasonable inference, yes, can be.
Reasonable.
The presumption of fact is an inference as to the existence of one fact from the existence of some other fact, unless the truth of such inference is disproved. To explain what constitutes a prima facie case to make Section 106 of the Evidence Act applicable, we should refer to the decision of this court in Mir Muhammad Supra, wherein this court has observed in paragraph 36 and 37, respectively, as under. In this context, we may profitably utilize legal principle embodied in Section 106 of the Evidence Act, which reads as follows. When any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. The section is not intended to relieve the prosecution of its burden to prove the guilt of the accused beyond reasonable doubt. But the section would apply to cases where the prosecution has succeeded in proving the facts from which a reasonable inferences can be drawn regarding the existence of certain other facts, unless the accused, by virtue of its special knowledge regarding such facts, fail to offer any explanation which might.
Tuhan Paisa. Buto itu. Buto pa rin.
Section 106 cannot be invoked to make up the inability of the prosecution to prove evidence against the point in the indictment.
Next para goes in our favor of the judgment. Para 87 of the judgment.
Let us read from 86. Paragraph 86, my lord.
The problem here, there's a lot of gaps. One is that, you see, the the persons who had said that the accused was the culprit. Now those victims have not been made witnesses.
Yes.
The wife of the appellant also has not been made witness. Okay, that can be understood because
It's her husband.
her husband, so probably. But then you see, now let's go to PW1. PW1.
Kamala Tanvir. It's the wife of the victim.
Huh.
Kamala Tanvir কবে লাগে?
So this is also inference. Then in comment, I know so PW2 accused so was present in the house in the quarter. The villagers told the accused Dana so had Suku. Now, who are those villagers who said that?
Let's say lapses are there, lordship, whether it is vital.
It is
Because this accused person who was very much present in the place of occurrence, he did not make any hue and cry. He did not utter anything. The person is dying, your lordship. If somebody has come and assaulted him, being a reasonable person, he should have uttered, my lord.
No, but where is the evidence of the IO that he tried to find the dove? Nothing, no explanation. And PW2 says that about 10 persons were already present at the place of occurrence before I reached there. Then he says that I have stated that I have killed him as I heard from the villagers. Now, who are those villagers? Then let us go to PW3. PW3 says that one Sukta,
Yes.
Sukta, a laborer of the tea estate informed. Now, Sukta is not a witness.
So here in the prosecution case raised on primarily on PW 1 and 2. So your lordship will judge whether the evidence of these two persons is sufficient to convict.
Now you see one thing. That is what we're trying.
Yes.
That's
My
what
lord.
this causes.
My lord.
PW2 says
Yes,
that the accused was present at the place of the crime.
my lord.
Okay, so that is
His version.
that is not good for the appellant.
Yes.
But you come to PW3 when he says PW3 also says that Sukta that he did not make a statement before the police that Sukta had informed him. Okay.
Yes.
Then he says out here, I did not see Dania Sobor at the place of occurrence when I reached it. I did not see who killed Swendu. Since Dania Sobor was not available in his quarter, it was suspected that he killed Bijoyta.
So that is a subsequent event. PW3, she arrived subsequently, my lord.
Do we know that? How do we know that she arrived subsequently?
Is whether this PW3 was present or not, PW2 doesn't say so. From evidence of PW2, it's not apparent whether PW3 was present or not. But PW2 says, lordship, accused Hania Sobor was inside the quarter. But lordship, when PW3 arrives, she says that she was not present, he was not present. So apparently, Lordship, when PW2 arrived, this PW3 he was not there. Since she did not witness
No, you see,
accused person.
PW2 says when he arrived,
Yes,
okay, he found the deceased dead.
yes,
Okay, he was
Yes.
dead. When PW3 says that when he arrived, he saw the deceased wet with blood and in a moribund condition.
condition.
Now, what is a moribund condition? Moribund condition doesn't mean dead, just means
Yes.
lifeless condition
Almost like,
or nearly dead.
yes,
So, if he's almost dead, that means he came earlier. PW3 came earlier. You cannot come back to life. PW3 came earlier in point of time. He was in a moribund condition.
true.
The problem is prosecution has, I mean, the 106 can be applied, but then there's a contradiction between these witnesses. And where is the weapon? Where is the evidence of the witnesses that the weapon was there? Or it had been thrown away, or they have tried to seize it.
Yes. It was a-
6 years, 4 months.
It appears that because of the quarrel he went, then they started quarreling because PW3 says that, I think. PW3, he says, I heard Dhanya Sabor hacked Bijoy Tanti following a quarrel between them.
Yes. Even PW1 says so, there was a
So
dispute.
there was a quarrel between them.
Yes,
So that way 304 can be maybe
attractive.
attracted. You know,
Man.
using, but we don't know whether the provocation was grave or sudden,
Man.
because no one knows that. But then more than that, can a conviction be sustained in this manner? When there is no eyewitness, when the eyewitness or when the person who said that they saw the accused killing so and so are not made witnesses. Not made witnesses at all. That Sutka was not made a witness.
So there's
Those villagers also, no
missing link.
discrepancies. Yes.
But your lordship, at the same time, it's a case of 106. So lordship had to balance that. Case the occurrence which had taken place inside the four corners of a house. It's apparently.
No. Four corners of yes. The problem is you also no alibi.
Yes.
But my lord,
No alibi.
yes, LDB, that was not, because perhaps, my lord, because immediately after, my lord, incident, he was arrested. So all along he was behind the bar. So perhaps that is why he could not assist his counsel.
He did not make any UN crime, my lord, when the occurrence had taken place. If he is not the perpetrator, he
The
remains.
problem is PW3 says that he did not see the evidence.
Yes.
Yes, yes. But he also didn't say so, my lord. He was caught, but he didn't say I was not present. I was somewhere else.
Look out here. Wife of the accused is PW4.
Yes.
The wife of the accused said that Dhanya Sabor cut Bijoy Tanti when he came to subside the quarrel that cropped up
Yes.
between.
Yes.
Now the wife of the accused not made
Not
a part-
informed.
Not made a
Not a
witness,
party.
no statement taken.
She should have been the best witness, my lord. Yes.
That is
Being
right.
the eyewitness to the occurrence.
So what is police doing?
She is not charge sheeted also, my.
That is not required, but at least some explanation should have been given.
Lord.
Some statement of worship is
Yes.
recorded. Is any statement recorded?
Sir, but you have not.
Wife statement is not there, perhaps. I have gone.
Banamasile, sign.
Then this PW4 does not make the statement to the police. Very badly
Investigated, my lord.
conducted, very bad. The wife of the accused was not questioned in the cross-examination of the IO.
Who's নাম কি?
Konya.
Accused নাম?
Accused.
Huh?
Manya Sabur.
No, not there, my lord.
My
Her statement is not there.
Not only that, there is no evidence regarding any weapon.
Weapon, my lord, there are defect in the investigation.
Where is the evidence of the IO that he tried to find the weapon or that he was cut by a dao? Where is that?
And my lord, the particular ZD entry, my lord. In ZD entry also, neither accused name mentioned nor victim.
Yes,
Because that is the first information, that is why.
Does it matter? Then they're just going to be the start of a case. How will they know everything? When a FIR is not an encyclopedia, how can a GD entry be an encyclopedia?
Sometimes GD, sometimes FI. I don't know this one, no? You can see. মনে মনে করবো রিসার্চ করতে হবে No, sure, leave it to Lordship's discretion.
No, it's okay that you leave it to us. You have to leave it to us. But the problem is we are trying to find it. This is very difficult to sustain the conviction. And even if we are trying to alter it to 304, there also we are having a problem. Though it appears that
It's the case of single blow. Lordship may,
he's a single blow agreed.
yes.
But we are leaving it all. You see, it is done by a Dao. But who wielded the Dao? No evidence. No evidence. where is the IO trying to recover the DAO or find out? No statement, nothing given. The IO also blank. Nothing is there.
99% cases, lordship finds, my lord, lapses in the investigation.
This one is very bad.
Yes, my lord.
Very difficult. Though it appears that 304 should be applied, but even that to apply that also, and to convict, I don't know how it can be, they can convict.
Single blow,
Yeah, there are six
single blow, no, no, exception.
during writing the judgment. So, okay, right, Mister
NK Kolita,
N.K. Kalita, Leonard amicus or what?
amicus.
Learn amicus cure. Also heard Miss B. Buyan, additional people. This appeal has been filed against the impugned judgment dated 31/5/26, passed by the Sessions Judge Vishwanath Charyal in Sessions Case for 8 of 22, by which the appellant has been convicted under Section 302 IPC for having caused the death of his neighbor Bijoy Tanti, Bijay Tanti, Tanti, who had come to the house of the appellant to stop the appellant and his wife from quarreling. No, from wife, who were quarrel. Full stop. The appellant was thereafter sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees
5,000.
5,000, in default, a rigorous imprisonment for 1. Next paragraph. The prosecution case in brief is that the wife of the deceased, who is also prosecution witness 1, bracket PW1, submitted an FIR dated 23/6/2019 to the officer in charge of the Gingia Police Station, GINGIA Police Station, stating that at about 10 p.m. on 22/6/2019, the appellant had killed her husband by hacking him with a dao, following an altercation on a trivial matter. Consequent to the FIR, Gingia case number 81 of 2019 and the section 302 IPC was registered. Gingia, okay, Gingia. After investigation was completed by the investigating officer, a charge sheet was submitted by the IO, having found by the IO bracket PW6, right, having found a prima facie case under section 302 IPC against the appellant. Next paragraph. After the case had been committed to the learned Sessions Court, the Sessions Court frame charge under section 302 IPC against the appellant, to which he pleaded guilty, to which the appellant pleaded not guilty and claimed to be tried. The learned trial court thereafter examined 6 prosecution witnesses, and after examining the appellant under section 313 CRPC, it came to a finding that the appellant was guilty of having caused the death of the deceased. The learned trial court thereafter convicted the appellant under section 302 IPC and sentenced him, as stated above. Next one. The learned amicus curiae submits that there were no eyewitnesses to the crime and no weapon was seized by the. He also submits that the circumstantial evidence was not complete to justify the learned trial in convicting the appellant under section 30. Anything else? That's all.
Well,
That's good.
because vital witnesses were also not examined.
He also submits that the vital witnesses who had allegedly seen the crime as had been narrated in the testimonies of the prosecution witnesses, had not been made prosecution witnesses by the police. And in the absence of their evidence, the section 302 IPC could not have been said to be proved against them. He also submits that section 106 IPC is not attracted
Yes.
to the facts of this case, inasmuch as the prosecution had not been able to produce circumstantial evidence pointing to the guilt of the appellant. That's all. On the other hand, next part, the learned APP submits that the evidence of the prosecution witnesses provides a complete set of circumstantial evidence which only points towards the guilt of the appellant and leaves out any hypothesis that the appellant is not guilty of the crime. He submits that the evidence of the witnesses goes to show that the appellant and his wife were quarreling, for which the appellant had gone, for which the deceased had gone to the house of the appellant to stop the appellant and his wife from quarreling. Full stop. However, the attempt by the deceased to pacify the appellant and and his wife from quarreling ended with the appellant and the deceased quarreling, which ultimately led to the death of the deceased at the hands of the appellant. Full stop. She submits that even though there was no recovery of the weapon, comma, the fact that a sharp knife / dao had been used on the deceased was proved by the evidence of the medical doctor and the other prosecution witnesses in terms of the injury inflicted upon the deceased. So she submits that when the evidence of PW2 is to the effect that the appellant was in his house when the body of the deceased was discovered in the appellant's kitchen, comma. The same required the appellant to explain the cause of death of the deceased in his house. However, the appellant did not give any alibi He submits that when the guilt of the appellant has been established by the circumstantial evidence, and as the death of the deceased had occurred within the four walls of the house of the appellant, the appellant was required under section 106 IPC to prove / explain as to how the death of the deceased had occurred, which was in the special knowledge of the appellant. In the absence of any alibi or the reasons for which the appellant what have I said? Or the reasons for which the appellant, the deceased had died. The look, I said again, just read. In the being given, not comma, being given by the appellant, comma. It could be assumed that the appellant had caused the death of the deceased. Anything else?
Non-examination of the vital witness.
What?
It's not fatal according to the prosecution because PW 1 and 2 proved that he was very much present in the place of occurrence, appellant, and he did not make any hue and cry, and there is no explanation also.
So next para. The learned PP additional PP submit that non-examination of the vital witnesses does not weaken the case of the prosecution, keeping in view the fact that the evidence of PW 1 and 2 had proven the presence of the appellant at the scene of the crime. However, the appellant had not made any hue and cry with regard to the deceased dying in his kitchen. Full stop. As such, the no full stop. As such, the appellant had failed to prove his burden of not being the cause of death of the deceased. That's all.
Defect in the prosecution case
Huh?
is not fatal. Defect, there is defect according to your lordship.
He submits that the defect in the prosecution case is not fatal. Huh? That's all. You want to say defect? You are admitting.
The lapses, my lord, lapses. Lapses in the prosecution case will not like falsify the case of the prosecution that the accused person was the perpetrator of crime.
See, okay, right. He submits that though there are some lapses in the investigation of the case by the prosecution, however, the same would not weaken the case of the prosecution. That's all.
Lordship, if lordship permits, may I go to some other?
Yeah, have you relied on some judgment?
Yes, yes, on non-examination of material witness, 2015-11 SCC 43,
Full stop.
books were given.
He submits that non-examination of material witness is not fatal to the case of the prosecution. And in this respect, she has relied upon the case of Raja alias Rajinder versus State of Haryana, 2015-11 SCC 43. Which para?
13,
Bracket para 13. Huh? Thirteen, 1-3.
1-3.
That's all.
13, yes, at least I'll suffice your lordship.
Okay, right. We have heard the learned counsel for the part. As can be seen from the submissions made by the counsel for the party and the evidence adduced by the learned counsel, the deceased had gone to the house of the appellant, in an apparent bid to stop the appellant and his wife from quarreling. The evidence of PW 2,
One also said.
three, is to the effect that one, we said one.
What, my lord? Regarding resolving the dispute.
That's why in a bit too. This is apparent from the evidence of PW 1, the wife of the deceased. Oh, cool. However, it appeared that the attempt by the deceased to help the appellant and his wife from quarreling, not to help, to help them from quarreling, ended in disaster, as the appellant as the deceased ended up dead in the kitchen of the deceased appellant with a with neck with his neck being cut. Pushpa. Next part. The evidence of PW2 is to the effect that when he went into the house of the deceased, he saw the deceased lying dead in the house of the appellant with his neck cut. PW2 further stated that the villagers had told him that the appellant had hacked the deceased. He also stated that the appellant was present inside the house, inside his own house. Next para. The evidence of PW3, who is a teacher, is to the effect that one Sukka, S-U-T-K, a laborer of the tea estate had informed him that the appellant had hacked the deceased. On going to the house of the deceased appellant, he saw the deceased lying in the veranda of the residence of the appellant. The deceased was wet with blood and was lying in a moribund condition, moribund condition. There was also a cut injury on the neck of the. He also stated that the residence of the appellant and the deceased were adjacent to one another. He informed Rajan Bora, and thereafter the Jinjia police station was also informed over the incident. We also heard that the deceased had gone to his neighbors, to the house of the appellant, on hearing a quarrel between the appellant and his wife. Thereafter, the appellant and the deceased had a quarrel. In his cross-examination, PW3 stated that he did not see the appellant at the place of occurrence when he reached there. And that since the appellant was not available, it was suspected that he killed the deceased. Next part. The evidence of PW4 is to the effect that PW3 had informed him over phone that the deceased had been killed by the appellant. On reaching the place of occurrence, he saw the deceased lying in the house of the appellant in a grievously injured condition and in a moribund state. The police were informed. The police were also informed. Thereafter, PW4 thereafter stated that the wife of the appellant had told them that the appellant had cut the deceased when he came to intervene in the quarrel that had cropped up between the appellant and his wife. Next subpara. In his cross-examination, PW4 did not deny the suggestion that he did not tell the police that the wife of the appellant had told him had told the police that a quarrel had taken place between PW4 and her husband and the appellant. And that the appellant had cut the deceased when he had intervened in their quarrel. Next para. The evidence of PW5, who is the doctor, is to the effect that he conducted post-mortem examination on the deceased and his findings was that there was bleeding over neck due to one incised wound of size 4 into 2 into 0.5 inches over left area of larynx, extended up left posterior, so page 17. The evidence of PW five was that death occurred due to cardiorespiratory failure as a result of the injuries sustained. Next para. The evidence of PW6, who is the investigating officer, is to the effect that he was informed over phone with regard to the killing of the deceased. And when he reached the place of occurrence, he saw the dead body of the deceased lying in the residence of the appellant. An inquest was held over the dead body. Two witnesses, namely Raju Sawtal, SAWTAL, and Anil Sawtal, SAWTAL, bracket PW2, were questioned and they stated that the appellant had hacked the deceased following a quarrel. PW6 further stated that the informant had lodged an FIR and that he also stated that he recorded the statement of the witnesses and sent the dead body to the hospital. He went to the place of occurrence and drew a sketch. On finding incriminating materials against the appellant, he submitted a charge against the appellant. Under section 302, yeah. In his cross-examination, PW6 states that he did not question the wife of the appellant. Next part. The examination of the appellant under section 313 CRPC reveals that the appellant had made a blanket denial with regard to all the evidence that had been recorded against by simply saying, it is false. Next part. Next part. As can be seen from the evidence, there is no direct evidence proving the guilt of appellant. There are no eyewitnesses and neither have the material witness, that is Sutta, that is one Sutta, or the villager been made prosecution witness. In the case of in the case of Raja versus State of Haryana, the Supreme Court has held that non-examination of a material witness is not a mathematical formula for discarding the weight of the testimony available on record, if the same is natural, trustworthy, and convincing. The problem in the present case is with regard the fact that there has been no explanation given by any of the prosecution witnesses as to the kind of weapon that has been used for cutting the knife of the deceased. It is quite apparent that a sharp-edged weapon has been used for committing the crime in question. However, there has been no attempt at giving an explanation as to why the prosecution had not examined the witnesses and the appellant or others with regard to the weapon used for committing the offense. Further, the further, though there appear to be material witnesses, comma, no attempt has been made by the prosecution to make the said one Sutka and other villagers who had stated that the appellant had killed the deceased come out to be made prosecuted witness. The entire case rests on circumstantial evidence. Next part. No plea of alibi has been taken by the appellant that he was not present in his house at the time the deceased had died. It is also not the case of the appellant that he did not quarrel with his wife or that the deceased had not come to his house at the relevant point of time. The appellant is conspicuously silent with regard to his whereabouts and what he did at the relevant point of time. He has also given a blanket denial in his examination under section 313 CRP and has not even attempted to make any explanation to the effect that he was not at all connected with the crime in question for whatever reason. No, for any reason whatsoever. The non-explanation of the appellant having attempted, no, the appellant not having attempted to make any explanation with regard to how the appellant had died, how deceased had died in his house during his examination, during his presence, leaves us with a doubt as to why the appellant is keeping that. Next part. Section 106 of the Indian Evidence Act, 1872, states as follows. It is no doubt true that Section 106 Evidence Act cannot be invoked to make up the inability of the prosecution to produce evidence of circumstances pointing to the guilt of the accused. However, the question in the present case is as to whether there has been a failure to produce circumstantial evidence. Further, in the case of so and so, the Supreme Court has held that the failure to attempt to make any explanation under Section 313 CRPC, dash dash, okay, next you're right. Okay, right. On considering all the above facts, we are of the view that though there has been, though the investigation conducted by the police has not been, has left out certain vital facts. The chain of circumstantial evidence forms a complete circle which only points to the guilt of the offender in committing the crime. Crime of killing the deceased. However, there is nothing to show that there was any previous enmity between the appellant and the deceased. In fact, the chain of events leading to the death of the deceased goes to show that the appellant who intervened in the quarrel between the appellant and his wife as a peacemaker ended up being a victim of the inflamed passion of the appellant, who apparently lost control of his senses, who apparently lost his power of self-control, where the quarrel between the appellant and his wife, ended up being a quarrel between the appellant and the deceased. This is quite apparent from the evidence of PW3, who stated that the appellant hacked the deceased following a quarrel between them. the attempt of the next para, the attempt of the deceased being a peacemaker apparently appears to have boomeranged on the deceased as the appellant has perceived the interference of the deceased as a grave and sudden provocation on the family quarrel between the appellant and his wife. This grave and sudden provocation in the heat of the quarrel between the appellant and the deceased, in our view, comes within the provisions of exception 1 to section 300 IPC. And as such, we are of the view that the act of the appellant while being while under the sense of while under the loss of self-control amounts to culpable homicide not amounting to murder. Consequently, we are of the view that section 302 IPC is not attracted to the facts of this case, and section 304 part 2 would be attracted, IPC would be attracted to the fact of this case. Next, accordingly, we are not in agreement with the decision of the learned trial court in convicting the appellant under section 302 IPC. The conviction of the appellant under section 302 IPC is accordingly interfered with and set aside. The appellant, we find the appellant guilty of culpable homicide without the intention to cause death of the deceased. Where's the 304? 304. Was aware of the view that the act of the appellant was done with the knowledge that his act would likely to cause death, but without any intention to cause death or to cause such bodily injuries as is likely to cause. Accordingly, we convict the appellant under section 304 part 2 IPC and sentence it to undergo
It is your maximum is
10
10 years, my lord. So he has already, my lord, 6.5 years.
Yeah.
Period maybe
Accordingly, convict him to undergo, sentence him to undergo rigorous imprisonment for 6.5 years.
6 years already gone. Lordship, the gravity of the offense, your lordship will kindly see.
Yes,
Vital
Without
part,
intention,
yes.
but it was too harsh, my lord.
no weapon. You have not made any, your prosecution, you have not made any mention.
Lordship, minimum 10 years, my lord. He has taken the life of someone.
To part 2.
But maximum is 10 years.
Maximum is
No, what I
Part one.
want to make submission, my lord, part 1 maybe. Intention,
not part 1, this is part 2.
Yes.
We are giving
6.5 maybe too late, my lord. Lordship kindly
Okay. I just said it. So 7 years. 7 years. 7 years with a fine of rupees, how much was it earlier?
5,000 was there.
5,000. And in default to undergo imprisonment for
1 month was there.
1 month.
Yes, I.
Whatever, doesn't matter. The impugn judgment and sentence are accordingly interfered. The appeal is accordingly modified to the extent indicated above.
Partly.
The impugn judgment is accordingly modified to the extent indicated. Send back the PCR in appreciation of the assistance provided by the learned advocate.
Married.
The appeal is accordingly allowed to the extent indicated. Okay.
Rightly done. Because lordship, the weapon was not seized.
We were half a mind to set aside the judgment order.
Yes.
We have got a thing, we have got one thing, in the case of this right, somewhere I'll put it. In the case of state of MP versus Balveer Singh,
Yes.
325, 2025, SCC page.
But it is SCC online, madam.
No, this is what is the page number? Get everything.
SCC online 390.
The Supreme Court has held as follows. Yes.
On full model 11, again, in matter coming out of that series, my lord. Model, if it is not taken, next, my lord, your lordship is 1920, my lord. 19 or 21. If matter not taken, your lordship may take up the bail matter, my lord. The matter is coming again and again, my lord.
You have to serve 24 law.
24.
24.
No, no, last week, not that one.
তাহলে আপনি 21 অফ নেবেন 21
No, 22, 21.
না থাকিব পাৰো কোন
19 was also
20 লোক আছে
22. 2066.
The party, this is the matter on 20.
21 was there.
21
Huh? What about item 10? There is lab, something has to lapse at time.
20.
What does this matter?
Lordship, that remission letter, my lord.
Lordship, the report, that matter is now pending before the review board. So what
Let-
decision 24/9/25 Lordship order?
No,
is there.
there's,
I don't-
the previous communication it was stated, the proposal will be placed before the state level review board Assam for consideration.
Who do we take, who do we ask for a report?
IG prisons. It was of 22/9, whether it was,
You have the instruction.
yes,
Okay, right.
last time I submitted the instruction.
Ms. B. Puyan, PP shall obtain instructions from the IG prison as to the proposal for remission.
Decision,
Huh?
decision.
No,
এটা কোথায় আছে?
they say subsequently the proposal will be placed before the state level review board Assam
As
for consideration.
as to the decision taken by the authorities with regard to the remission
Yes,
of the
Appellant.
appellate. That's all,
my lord.
by the next date. Is the matter on?
3 weeks.
After 3 weeks,
Is
Date.
matter after thinking about it? Okay,
my lord.
yes, but,
Item 16, lordship,
yes, what is it?
Matt appeal, lordship.
Yes, what about, no time, 310 August.
Oh, lordship,
30
lordship,
August.
fix a date, lordship, fix a date. Can you?
Who's for the other side?
Answers.
It is what?
December.
No, you are not compromising, nothing. Who is the wife?
I'm the wife.
What do you are challenging? What? Divorce decree?
No, I'm the for granting alimony, lordship, permanent alimony.
Permanent alimony.
but-
What about you? Are you agreeable?
My lord, already I am maintenance is pending, my lord. Maintenance is
Your maintenance has been not given.